Good afternoon, everyone. My name is Paula Fagan. I'm CEO of LGBT Ireland, and I'd like to warmly welcome you to today's webinar, which is exploring the legal relationship, parent and child relationship in LGBTI parented families. We are delighted to have partnered in LGBT Ireland with Dr Lydia Bracken of the University of Limerick to undertake this research, which looks at the pathways to parenting for LGBTI people, our family structures, and also the legal barriers that LGBTI families, some families continue to face, and the impact that these barriers have on their daily lives. Today, we'll hear about those challenges, but more importantly as well, we'll also hear about possible legal solutions from our expert panel. This couldn't be more timely, as we know the government are this week looking at setting up an Oireachtas committee to examine how they'll best develop legislation around assisted human reproduction. Legal solutions simply have to be found. So we're delighted to have some of the leading experts in AHR and children's rights here to talk to us today about what those possible solutions can be. Before I hand over to the chair for today's event, I would like to formally, on behalf of LGBT Ireland, thank Dr Lydia Bracken for this research and also for all of the work that she has done in putting forward the experiences and also looking for legal solutions to support LGBTI families. She's been helping us and supporting us for many years now as we've campaigned for legal change on this issue. And we just can't thank her enough for all that she has done. I'd also like to thank our other panelists, Maeve Delargy, who's a member of the AHR Coalition's Legal and Medical Working Group, for all the work that Maeve has done, and many of you will have heard her out there on the airwaves on fighting for LGBTI family rights, and also for Professor Conor O'Mahony, the Special Rapporteur for Child Protection, again, a huge advocate for children's rights and for looking at legal solutions for all families so that children can have their families legally recognised. I'd like to thank you all for coming along to today's event. And just by way of housekeeping, if you do want to use the live caption function, you can do so by pressing the live caption function at the bottom of your screen. And also today's event will be recorded and we will be circulating that recording afterwards. There's also a little Q&A box down at the end of your screen. And if you want to pop your question in there, we will hopefully have time for some questions towards the end of today's discussion. And now I'd like to hand over to our chair for today, which is Roderick Maguire. And Roderick Maguire is a board member, a very active board member of LGBT Ireland. He's also a member of the Legal and Medical Working Group for the AHR Coalition. Roddy, as we know him, Roddy is a barrister of law and specialises in criminal and civil law. He also is chair of He's chair of the Mental Health Tribunal, a member of the Residential Tenancy Board, and a member of the Criminal Injuries Compensation Tribunal. So we're in safe hands, Roddy. I'll hand over to you. Thank you.
Thank you very much. Thank you very much, Paula. I'm delighted to be here today and share the event on such an important topic. The immense scholarship that's evident from Dr. Bracken's report is clear, and this is a really important contribution to the area at this time. So the running order today is, first I'm going to ask Dr. Bracken to speak about her report, then Professor O'Mahony will respond, and then we're going to hear from Maeve Delargy about the experience of her wife and her daughter. As has been said there by Paula, we will have time for a discussion afterwards. And if we don't get to your question in the panel, we will respond to all questions by email. So please do put any questions or concerns in there, please. Also, as Paula has said, this is going to be recorded and it will be available on the LGBTI website. So please let people know. So Dr. Lydia Bracken is the Assistant Dean for Equality, Diversity and Inclusion in the Faculty of Arts, Humanities and Social Sciences, and is a lecturer at the School of Law in the University of Limerick. Lydia researches the areas of child and family law with a particular focus on the legal recognition of quote-unquote non-traditional and new families. Lydia is the author of 2 books in the area, Same-Sex Parenting and the Best Interest Principle, Cambridge University Press 2020, and Child Law in Ireland, Clara's Press 2018. She's the author of this report on LGBTI plus parent families in Ireland, legal recognition of parent-child relationships, which was supported by the Irish Research Council New Foundation Scheme 2020. So if I could hand over, please, to Dr. Lydia Bracken. Thank you.
Hello everyone, my name is Dr. Lydia Bracken. I'm a lecturer at the School of Law at the University of Limerick, and I am the author of a report on LGBTI plus parent families in Ireland, legal recognition of parent-child relationships. The project that gave rise to this report was a collaboration between myself as the researcher and LGBT Ireland as the research partner. It took the form of empirical research, which was conducted through an anonymous online survey that was open for responses in June and July 2021. The research is supported by the Irish Research Council New Foundation Scheme 2020. In this presentation, I will provide an overview of the key findings from that empirical research. Further information and more details on those findings can be accessed in the report itself. So to provide some background to this research and to explain the motivation for it, for anyone who is not familiar with this area, Irish law currently allows for some LGBTI plus parents to be recognised as legal parents of their children. Legal recognition is, however, dependent on the mode of conception of the child, so that is, how the child was conceived. And as a result, many LGBTI plus parent families cannot secure full legal recognition of their families. In many cases where there are 2 parents, only one parent is regarded as a legal parent of either the child or the children of the family. The objective of the current research was to generate a picture of the number and structure of LGBTI plus parent families that exist in Ireland, their chosen pathway to parenting, and their experience of obtaining legal recognition of their family relationships. The data gathered through the empirical research was subsequently assessed against international standards to understand whether our current practice in Ireland meets our international human rights obligations. In terms of the data collection, this was done using a self-administered anonymous online survey. The majority of questions in the survey had fixed response options, while a small number of open-ended questions were included. So this allowed for both quantitative data and qualitative data to be collected. The questions that were used in the survey were developed in collaboration with LGBT Ireland, and sample questions were circulated to a small number of LGBTI plus parents for feedback prior to the survey being made available. The survey then went live between June and July 2021. The anonymous survey was completed by 99 parents who identified as LGBTI+. Of these, the vast majority, that is 90%, indicated that they share parenting with a current partner, while 7% share parenting with a former partner. And I should explain that the word partner here includes either a spouse or a partner. 3% of the respondents stated that they parent alone. The survey asked that families would complete the survey once, so that is one parent answering on behalf of the other parent or parents, unless this would not accurately describe the nature of the family. Assuming that this request was followed, it can be estimated that the survey represents the views of 195 parents, parenting approximately 170 children. In this way, the survey is not representative of the views of all LGBTI plus parent families, but instead highlights issues that are faced by some parents in securing legal recognition of their family relationships. One of the key findings in the report and the research relates to legal parental status, so that is, who are the legal parents of the children. I appreciate that the figures which are being shown to you on the current screen are quite small, but these can be viewed in the report itself. Overall, most respondents said that they are a legal parent of all of their children. And of the respondents who indicated that they share parenting with a current or former partner, most indicated that that partner is legally recognised as a parent of all children. However, when it came to looking at joint parental status, the figures dropped. So of those respondents who indicated that they are a legal parent of all of their children, only 47% stated that the person they share parenting with is also a legal parent of all children. So therefore, in 53% of the families that are captured by the survey, all children do not have a legal relationship with both of their parents. This indicates that a significant proportion of LGBTI plus parent families are not fully recognised under Irish law. And by not fully recognised, I mean that where there are two parents, both parents are not legally recognised as parents. The data on guardianship was broadly similar to the data on legal parentage, but there were slightly more guardians than legal parents. So again, most respondents indicated that they are a legal guardian of all of their children, and most of those who are parenting with a current or former partner stated that the person with whom they share parenting is a legal guardian. The percentages fell again when looking at joint guardianship, although the number of respondents who indicated that both they and their partner are legal guardians of all children was higher than the numbers reporting joint legal parentage that we just looked at on the previous slide. So guardianship refers to a bundle of rights and responsibilities that are associated with raising a child. Although most legal parents are legal guardians, this is not always the case, and for many parents will depend on their marital status. There is also a provision in law for someone who is not a legal parent to apply to become a guardian, but there is a 2-year waiting period before they become eligible to apply. The relatively high proportion of families in the current survey where both parents are not legal guardians of all children, that is 47%, may be explained by the fact that there is this 2-year waiting period before someone who is not a legal parent can apply for guardianship. It could therefore be the case that in some of these families, the child or the children are under the age of 2 years old, and so the parent in question does not yet meet the eligibility requirements to apply for guardianship. The survey also asked respondents about their experience of discrimination and attitudes. Most respondents felt that Irish society is probably accepting of LGBTI plus parents. And in the fixed response question about discrimination, 51% of respondents stated that they had not experienced discrimination as a parent because they are LGBTI plus. However, that still left 42% of respondents who indicated that they had experienced discrimination as a parent because they identify as LGBTI plus, which is quite a significant proportion. The respondents who indicated that they had experienced discrimination were invited to describe the nature of the discrimination in the comment box if they were comfortable doing so. Many of the comments related to heteronormativity and concerned rigid administrative systems that failed to accommodate diverse family forms. For example, the first respondent here stated, "The system is set up for mothers to do child parenting. Lots of questions about no mother, all forms are mother. You are required to complete different forms and continuously explain how you are a parent." Other respondents mentioned a lack of acceptance or understanding of their family relationships among members of society. For example, this respondent stated that they had been told by strangers, etc., that my wife cannot be a parent of our child, as a child can only have one mom, etc. And then many respondents referred to the legal barriers they or their partner had experienced as a non-legal parent. So for example, one participant said, "Not being able to sign a form in creche for my son when he had an accident, as I'm not a legal parent." And another stated they were unable to sign hospital paperwork to consent to surgeries, scans, medical procedures, etc. These comments highlight the pressing need for legal reform to recognise diverse family relationships, but they also underline the fact that legal reform alone is not a panacea and that wider issues of societal understanding need to be addressed in order to accommodate all LGBTI plus families. The report also outlines the key findings by parenting pathway. So in this research, donor-assisted human reproduction, or DAHR, was the most common pathway to parenting used by respondents, and it represented 67% of all responses. 13% of respondents had engaged in surrogacy, 10% in adoption, and 10% had used a different or unspecified pathway to parenting. As you can see on the current slide, while more DAHR parent respondents were recognised as joint legal parents with their partner or co-parents than the general population, the proportion of joint legal parents was still just 50% among the DAHR parent respondents. This is despite the fact that DAHR is specifically regulated under the Children and Family Relationships Act 2015. So the research shows that the nature of DAHR procedures that are engaged in by Irish LGBTI plus parents varies considerably. By contrast, the Children and Family Relationships Act 2015 accommodates a narrow vision of DAHR. As a result, for many parents, the existing legal framework does not reflect or accommodate the nature of the DAHR procedure that was entered into. Among the families through surrogacy, none of the parents were jointly recognised as legal parents of all children, reflecting the fact that there is no mechanism available under Irish law to allow for such recognition. 60% of the adoptive parents reported that both they and their partner are jointly recognised as legal parents, but as noted in the report, for various reasons, it is likely that this proportion is actually lower than was reported. In the qualitative comments, all groups of parents again commented on the negative impact that the absence of legal recognition has on their lives. In addition, many respondents commented on their interaction with the court process, which was regarded as a negative experience by many. In response to these findings, the report on LGBTI plus parent families in Ireland, legal recognition of parent-child relationships, presents 10 recommendations concerning 3 core areas, namely the need for legal reforms to allow recognition of both parents, irrespective of the pathway to parenting that is adopted, the need to address heteronormativity and discrimination in administrative systems, and the need for legal information and support to be provided to LGBTI plus parents and prospective parents. To conclude, I wanted to highlight 3 particularly powerful quotes that were made by 3 different respondents to this research. Firstly, the government passes the buck from one department to another and shows little regard for the consequences for children and families. It has felt like I have stepped back into the closet and faced discrimination I have not experienced in several years as a gay man. As a gay parent, I have been made to feel less than, a headache for the passport office, and a second-class Irish citizen. I am not a parent in the eyes of the current law. Finally, it's exhausting being the family having to explain, justify, and seek a place for us within our society. There are many people who might believe that full equality was achieved in 2015 following the marriage equality referendum, but it is clear from the current research that many families remain unrecognised in Irish law, and I would urge the government and all policymakers to address this as a matter of priority. Thank you very much for your time. I'm now happy to answer any questions that you might have about the research.
Thank you very much, Lydia. And we're going to take questions at the end in relation to that. I'm going to now, very fortunate to have Professor Conor O'Mahony present to respond to Dr. Bracken's report and findings. Professor Conor O'Mahony teaches and researches about children's rights and constitutional law at the School of Law at University College Cork, And in 2019, as many of you will know, he was appointed by the government as a special rapporteur on child protection for a 3-year term. And in that capacity, he was tasked with producing a report on children's rights and best interests in the context of donor-assisted human reproduction and surrogacy. And that was published in April of this year. So I'll now call on Professor O'Mahony to respond. Thank you very much.
Thank you, Roddy, and thank you to everybody at LGBT Ireland and to Dr. Lydia Bracken for the invitation to participate today in what's a really, really timely presentation of this new report. And it's wonderful to see a report giving solid empirical evidence of the reality on the ground. These are issues, I guess, that people have known about for some time. And have been documented previously in Lydia's earlier published work. I mean, I should emphasize the report that I'm about to present really stands on her shoulders and the shoulders of others in a big way, because there has been an awful lot of very important and high quality research conducted in this area, looking at the potential legal issues arising from gaps in the law affecting LGBT families. But we perhaps didn't have quite as much in the way of empirical evidence of the realities on the ground. And so it's really fantastic to see the report now providing robust evidence of that nature to help to inform the ongoing discussion around reforms in the area. I'm just going to share some slides, just running through the details of the report, which I was asked to produce and which was published last April. So this report was commissioned in 2020. And this was at a point in time when the various government departments, there was a reference there on a previous slide to different government departments being involved in this. And the issue involves the Department of Children, the Department of Health, and the Department of Justice. And that does complicate the reform process somewhat. Following a meeting of an interdepartmental working group, I was asked ultimately in 2020 by the Minister for Children to produce a report looking at the area of the law governing donor-assisted human reproduction and surrogacy, specifically through the lens of children's rights. There are obviously other implications here affecting the rights of the intending parents, of surrogate mothers, but the particular focus of my work was really looking at the position of the children and the children's rights focus. And that would have been very much the focus that Lydia has brought in her previous work as well, which is why her earlier published work was such a valuable resource to me when completing this particular report. So the report was published in April, as I mentioned, and it's available on the Department of Children website. So I think LGBT Ireland are going to tweet a link to that after the event, or if you're having difficulty locating it, please feel free to send an email to myself. I'm going to run through a brief overview of the recommendations made in the report. I should stress they are recommendations. It is for the government to decide whether it wants to take these recommendations on board and follow them or not. And it remains to be seen what's going to happen in that respect. I don't have any particular inside track on what the reaction has been and what the likely direction of travel is going to be. But for what they're worth, here are the recommendations which I made. So there were some relation to donor-assisted human reproduction, but more relation to surrogacy. And that goes back to the fact that when it comes to DAHR, we have the 2015 Act, which does provide a foundation. It doesn't cover everything, and there are gaps in it. And so there were some recommendations in respect of addressing some of those gaps to try and bring more people under the umbrella of the 2015 Act with respect to DAHR. But we were starting from a much more developed place in that respect. So there's less focus on that in the report than there is on surrogacy. Of course, when it comes to surrogacy, we don't have any relevant Irish laws, not specifically tailored to surrogacy, and it ends up being dealt with by way of other areas of child and family law, which were never written with surrogacy in mind and which don't fully address it at all, which is an issue which has been repeatedly highlighted, including by the Supreme Court in 2014. And so we are really long overdue at this point to put in place legislation to properly address that. So if I start by just setting out some of the premises that I began with at the outset of the report. And the first of these is that when we look at the best interests of children, it can sometimes happen in debates around surrogacy and donor-assisted human reproduction that there is a degree of controversy around aspects of this. There are people who would rather see these practices, and particularly surrogacy, prohibited. And sometimes best interest becomes invoked on both sides of those arguments. But at the outset of the report, I make it clear that when we talk about best interests, it has been made clear by the relevant international human rights bodies that a best interest assessment must relate to the best interests of actual individual children and not some abstract notion of what is in the best interest of all potential future children. So we need to deal with the children that we have and not some abstract notion of children who haven't even been born yet. So that's important to be aware of from the beginning. The second point was that when we think about international surrogacy in particular, there is a reality here that we cannot legislate in Ireland for what happens in other jurisdictions. So if other jurisdictions choose to make surrogacy freely available, we can't change that. That's not going to go away. And we have to legislate for that reality in which we find ourselves. Irish couples are going to continue to engage in international surrogacy, irrespective of what we do with Irish laws. And so we need to be aware of that and legislate accordingly. Thirdly, then, and following on closely from that, the European Court of Human Rights has ruled in recent years that it is not permissible to have domestic laws which impose a blanket ban that preclude any possibility of recognising relationships arising from international surrogacy. There must be at least a possibility of such, and there must be a process facilitating that. So even if we were minded as a country to say we are going to impose a blanket ban and say we will never recognise any international surrogacy arrangements, we would be found in violation of the European Convention on Human Rights if we were to do that. So that being so, then the final premise which I took from that was, if we can't have a complete prohibitionist approach, well then really we are moving into the space of regulation rather than prohibition. And regulation not just of international surrogacy, but also domestic surrogacy, because if you're trying to regulate, you can regulate much more effectively within the jurisdiction than you can for what happens across borders. And so a core premise of the report was that it makes more sense to try to incentivize people to engage in domestic surrogacy, which we can regulate more effectively, rather than to engage in international surrogacy, where perhaps there are higher risks involved. So those are just some of the premises that informed the work. And to go on to some of the recommendations, when it comes to donor-assisted human reproduction, I mentioned that the 2015 Act already covers a good number of those cases, but there are exclusions. And the two core exclusions in the Act were non-clinical procedures, which are completely excluded, and in retrospective cases where the procedure was performed before the Act came into effect, and where the donor was known to the intending parents. And so the recommendations made in the report, they're both effectively are based on a conclusion that those exclusions are overkill really for what they are trying to achieve. There are legitimate goals perhaps underpinning those, but those goals are either not achieved by the exclusion of these families from the Act, or they can be achieved more effectively in other ways. So with respect to non-clinical procedures, the recommendation was that these should be included, that there would be a possibility of applying to court, so it wouldn't be automatic like the clinical procedures. You could have a court application for parentage or guardianship at any time after birth, and then the decision as to whether parentage or guardianship would be awarded would depend on whether identity records were available. And that's trying to strike a balance between, on the one hand, protecting the child's right to identity, while on the other hand also recognising the child's right to family life. And so it would incentivise people to avoid using anonymous donor gametes for that purpose. In respect of retrospective parentage, the recommendation was that the current proviso around known donors not being included there should simply be removed. The thinking behind that was about avoiding potential conflict. The analysis was that that wouldn't be effective. The conflict would happen irrespective of whether parentage was granted or not, in essence, and so therefore it didn't make any sense to maintain that particular exclusion. So if those recommendations were to be followed, we would see some of the people currently excluded from the machinery of the 2015 Act being able to access it alongside other families. In respect to surrogacy, then you are starting from scratch. You have to build this from the beginning. And so the report looks at both domestic and international surrogacy. And as I mentioned, it tries to incentivize domestic over international to try and steer people into that pathway. So the recommendation is to legislate for domestic altruistic surrogacy and to impose a process which is more attractive to couples considering surrogacy than it would be to go abroad. So the recommendation there is that for domestic procedures, it would be a preconception court process that parties could apply to the court for authorization for the procedure, and for transfer of parentage, before the procedure ever takes place, so that by the time the child is born, everything is squared away and they become parents of the child immediately from the moment of the child's birth. There would be provision in order to protect the interests of the surrogate. There would be provision for the surrogate to potentially raise an objection in the High Court during a prescribed period thereafter. But the default would be that the intending parents would be the child's legal parents from the moment of birth in domestic cases. With respect to international then, there is a reality that even if we have domestic surrogacy in Ireland, international surrogacy arrangements will continue to take place. We are a small country. It will be the case that some parents may struggle to identify a potential surrogate. And so we do need to look at this angle also. And as I've already mentioned, the ECHR case law requires us to do so. And so I think it's very important that the legislation includes this. There have been media reports lately that suggest this might not be included in the legislation. I think that would be enormously regrettable. It would leave a real gap and would be a significant flaw in the legislation if there isn't any provision made for this. Here, there would be a pathway, but the pathway would be different, and the pathway would be more involved and more burdensome, which goes back to the principle of trying to incentivize people to go for the domestic angle rather than international. It would be a court application after the child is born, but before the child is brought into the jurisdiction. And that would allow the court to double check to make sure that a range of criteria have been satisfied, including the compliance with the local laws where the arrangement took place, various issues around consent of the various parties, that there isn't any question of sale or trafficking of children, and so on. The report sets this out in detail, and people can check that out if they're interested. And similar to what I said earlier on about the non-clinical procedures, the recommendation here, again, to try to make sure you incentivize the maximum compliance with children's rights, including the right to identity, would be that you would have a provision here whereby full parentage could be awarded in the event that identity records could be available, which could be added to the register. If identity records were not available, you could have guardianship awarded, so you would have parental responsibility and decision-making powers, but not full parentage. And that, again, that's trying to strike the balance between recognizing the right to family life in all cases, while also trying to ensure that identity is equally protected in as many cases as possible. So that's for international surrogacy. And then in respect of retrospective arrangements where people are engaged in surrogacy arrangements before the Act came into force, the recommendation here was that, again, this would be a court application, and that provision will be made for courts to grant recognition of retrospective surrogacy arrangements based on similar criteria to those which I just outlined in respect of international arrangements, but additionally with provision here around ascertaining the views of the child, because in some of these cases, the child will be of an age and maturity where they would be in a position to express a view as to what they would like to see the court doing. And so obviously that would be in line with principles under the CRC and the Irish Constitution, that the child's views would feed into that. Finally, then on the right to identity, the right to identity here, again, we have some provision in the 2015 Act around DAHR. We have no provision in respect of surrogacy. The recommendations made in the report apply equally to both DAHR and surrogacy. Obviously, from a non-discrimination perspective, you would have to ensure that the right to identity is equally protected in both of those cases. And so the recommendation, it's important to note when we look at the 2015 Act, the 2015 Act allows for non-identifying information to be available before the age of 18, but doesn't legislate for identifying information to be made available until the child turns 18. Now, from a children's rights perspective, that means it's not a right of the child, it's a right of adults, because it doesn't crystallize until they become adults, whereas international human rights law would say that the right to identity is a right of children. So the recommendation in the report is that identity records should be available from birth. And it's important to stress, some of the media reporting around the report talked about them being available from 12. The recommendation is that they would be available from birth. However, the question then is who gets to make the decision and make the request to access them thereafter. Here the recommendation was that up to the age of 12, it would be for the parents exercising their role in guiding their children's exercise of their rights to access the information up to the age of 12. From age 12 on, that children will be independently able to access them. But as long as the parents were on board with that, that information could become available at any age after birth, and not only from the age of 12. But the report also emphasizes the importance of early disclosure. There's a lot of social science literature that speaks to that point, and so recommends, therefore, that where parents are considering engaging in DAH or surrogacy procedures, that they should be required to be counselled on the benefits of early disclosure, and to encourage them to make that information available to their children at the earliest available date, rather than waiting until later on, when the risk of adverse consequences flowing from that becomes higher. So that is the report in a nutshell. As I say, it's available online and people can look at that in more detail themselves. But the aim of it ultimately was to ensure that whatever we do in this respect in the forthcoming legal reforms are compliant with our children's rights obligations and provide the highest standard of children's rights protection in the area of DAHR and surrogacy. So it is now in the government's court to decide what it is going to do with those recommendations. So I'll be happy to follow up on that in questions later on. Thank you for your attention.
Thank you. Thank you very much, Professor O'Mahony, for those insights and a whistle-stop tour of your excellent report. And as well, I encourage all people who are tuning in or have an interest in the area, please to do read that report, as well as Dr. Bracken's report, really an amazing amount of work done in both reports, and huge contributions to this area. So now, if we can move on, I'm delighted to introduce Maeve Delargy. Maeve Delargy qualified as a solicitor in 2016 following completion of a law degree at BCL European at University College Dublin. She's currently an associate on the planning and environmental team at Philip Lee. She's a director of education with the European Women Lawyers Association, founding committee member of Outlaw, and founder of the Lesbian Lawyers Network. She's a council member of the Law Society of Ireland, with a very difficult election procedure to come through. So well done, Maeve. And junior vice chair of the Law Society of Ireland Younger Members Committee, and sits on the Dublin Solicitors Bar Association Younger Members Committee. And she is also the former chairperson of the Irish Women Lawyers Association. Some of you may have heard Maeve recently talking on Ryan Tubridy about her family experience, and I'm delighted now to ask her to share that with you. So if I could hand over, please, to Maeve.
Hi everyone. Hi Roddy, and thanks so much for having me. Thank you for that very kind introduction. Some of it's not relevant. I'm really glad it was, saying she's a solicitor in environment and planning. So my expertise in terms of the law is not in this area. So I'm more here today to share my personal story and that of my family. But I suppose to flag that obviously that's just one story, and there are so many families, as Lydia's study shows, that are affected by these issues. So this is kind of just one snapshot. So I've been introduced, but I would now like to introduce you to someone else. Just briefly, this is my daughter, me and my wife, and she's a little bit older now, a little bit bigger, but still loves that book. And we love reading it to her. So she does have two mums. She hasn't made no complaints about that so far, thankfully. Now, as I said, she has one, so perhaps we're kind of misinterpreting her babble as horror and disappointment. But we're hoping not. She seems happy so far. And I suppose the point of that is, that wasn't her choice. She's come into our family, and she's to deal with that life now, and all of everything that it involves, the good and the bad. And unfortunately, as Dr. Bracken and Dr. O'Mahony pointed out, the bad is, some of the legislation here that really impacts her rights. And kind of marks her out as different, I think unnecessarily, because everyone on our street has been so nice. Anyone we've met, has been so nice about this. So it's really the law that's going to be a problem for her, probably more so than attitudes of people. Ireland has come on so much, that really people are kind of nearly used to seeing a same-sex couple as parents of a family now, and may know one, and so that's not the issue. So my wife, as Roddy said, you may have heard some of this story. It was great to be on the the Round Tubbity radio show, sharing it, just highlighting this issue. So you may have heard some of this before, but my wife and myself went to school together. So we're lucky to still be friends with kind of the same group of girls that we would have gone through those 6 years together with. And amazingly now, we kind of can't really believe it, but a few of us would be parents now. All of us were very boring, very conventional. We all got married before having children. So that, that's very similar. There were lots of different types of weddings and types of ceremonies, civil ceremonies, some in churches, some humanist, everything. But, the result was we were all married. And then we had children. But I suppose, then the differences started because everything had been the same up to then. But for our daughter, she doesn't have two parents in the eyes of the law, whereas for our friends' children, they do. She just has one parent, my wife, because my wife was the one that gave birth to her. And I'm a stranger to her in the eyes of the law. And so I think as Lydia touched on, with some of the comments from her report, there are a lot of kind of practical implications of that, and some maybe that our daughter will encounter down the road that we haven't even thought about yet, or that she'll come up against those barriers or having to explain, and the forms not being right, and just that day-to-day stuff that is, you can get around it, but it's wearying. In some ways, I suppose she probably doesn't mind who takes her for her vaccines. She probably doesn't want anyone to take her, really. But she, that's something that I couldn't do because I wouldn't be able to consent to that. So it had to be my wife bringing her to all those appointments. Luckily, as I said, she doesn't really see much difference between us, but, those kind of things could, I suppose, spread into one parent becoming really the main parent and doing all those type of jobs, and then the relationship developing, and the non-biological parent like me kind of really starting to feel on the outside of things. If she was ever in trouble with something medical and my wife wasn't around to consent to that, I couldn't help her out in that situation. I would have no rights to, consent to a medical procedure or medical treatment or intervention. I'm nothing, I'm in terms of signing a legal document like that. The hospital, just couldn't really stand over that. I don't have a legally recognized relationship with her, despite, we obviously planned her together. We went through the pregnancy together and waited for her, and I've been there, since day one and looking after her, but that doesn't count. And then in terms of her inheritance, it'll be different, the inheritance she gets from my wife and the inheritance she gets from me, it'll be taxed differently. And that again is kind of nonsensical, considering, we're both working obviously for her betterment and have been from the start, and it, for it to be treated differently, it doesn't reflect the reality. So as has been said, there is a potential for me to get guardianship. That once she's 2, I'd be eligible to apply for that. I suppose that's, it's completely different to, that doesn't make me a parent, I suppose is what I'm trying to say. It gives me some of the rights maybe that a parent would have, but she will still only have one parent. And that, the guardianship won't change that. So maybe just to explain a little bit more about the story and why our daughter does only have one parent, and so that's the implications of these laws for our family and for our situation. Like all parents, we were just trying to make the best choices for our child and the best decisions that we could. And I suppose for us, after a lot of research and investigation and exploration into the potential for starting a family. You know, we knew definitely it was something we wanted to do. We were really, you know, from the very start of our relationship, we wanted to have children. So this was something we knew was going to be tricky, and you know, from a medical kind of point of view, we're missing one crucial ingredient. So we knew we had to plan this and really think about it and look into it. And so we did. And for us, the best thing for our family was not to use a sperm bank, but to try and find a donor that we knew who would donate his sperm to us. And we were so lucky that Siofra's very good friend, my wife, he offered to donate to us. And so we were then in a position to have a known donor. And we also thankfully didn't need the services of a fertility clinic. And so we were able to go through the DAR procedure in a non-clinical setting. But those two things ruled us out of the legislation. I suppose I should point out that going forward after the 4th of May 2020, children conceived now can have a known donor and go through a clinic. But when we were doing it, it wasn't possible. And so then we knew that the law in the UK was different, and that once you're married in the UK, they're happy that you're kind of that's all they need to see, and they don't really care, I guess, after that how you conceive your child, whether it's non-clinical or, you know, through a clinic. And so in the UK, we were able to both be the parents. And so at 39 weeks pregnant, we travelled up to Belfast and checked into a hospital up there and gave birth up there, which did have the effect of getting a birth certificate with both their names on it. But I suppose the issue is it's not an Irish birth certificate. It's a Northern Irish birth certificate, but it still is a very important document for us. And we're really glad to have it. But, you know, that was a huge upheaval, obviously, going up there. And that was, you know, just kind of a workaround, one of the many workarounds. Guardianship really is a workaround. Adoption, you know, is a workaround for something that Leisha should have, our daughter should have, just by rights, you know, by the fact of having two parents, and we shouldn't be kind of cobbling together potential solutions that maybe fix some of the problems. So I'm pregnant now, and so we're in kind of a really crazy situation where our daughter will have my wife as her parent, and then me as a guardian, and the next baby will have me as a parent and my wife as a guardian, even though, you know, we're all one family, we all live in the same house, and well, do our very best to treat everybody the same. So, you know, that really doesn't make any sense, and as I said, kind of doesn't reflect reality. So I guess that's kind of all the bad news, you know, in terms of the effect on our family and where we currently are. But I guess the really good news, and you can see that in Dr. Bracken's report from the recommendations she's made, you know, if those recommendations were implemented, that would really solve the problem for families like ours that have chosen in the best interest of their children, in their view, to either use a known donor and or go through the procedure in a non-clinical setting. So that's brilliant, you know, and also Dr. O'Mahony's report, you know, has similar recommendations. So that's really good to know that the legal experts in this area are on your side, and you're not kind of trying to convince them first and then moving on to the lawmakers. So, you know, I'm positive. I think it should be, you know, an easy win for the government. You know, they have these expert reports. They specifically commissioned Dr. O'Mahony, so they asked for it, and he's produced a report in the best interest of the child and made these recommendations. So now they just need to implement them, and they have a lovely, you know, vessel for all of those recommendations in the Assisted Human Reproduction Bill. So trying to be very positive and hopeful that you know, that everyone will see that this is in the best interest of the children, and kind of really worth doing for all the families like ours who are currently affected. And there is, as Paula mentioned at the start, you know, there's lots of work going on in this area. I'm sitting on the medical legal working group of the Assisted Human Reproduction Commission, or Coalition, which brings together groups and individuals from lots of different areas affected by these laws, you know, whether it's they've had to use DAR procedures because of infertility or disability. You know, there could be so many reasons. But we're all in the same position at the end of the day in not having legally recognised relationships with our children. So there is work going on there, and we will continue to make recommendations and provide as assistance as we can in terms of drafting and really showing that this is the best way to go. So happy to answer any questions, and I'll be here for the Q&A.
Thank you very much, Maeve, and congratulations on your news. That's great news. So I think I'll ask Professor O'Mahony and Dr. Bracken to put their cameras on, please, and we might have a discussion. Thank you very much for that contribution, and just if I could turn maybe to Lydia and Conor in relation to that. We've collected some questions, and they're frequently asked by parents who come to LGBT Ireland, and how Maeve has formed her family and is forming her family is similar to many, particularly female couples who contact LGBT Ireland, and they've used a known donor, or they're considering using a known donor. And why wasn't that dealt with in the 2015 Act, in the Children and Family Relationships Act? And how do you see, Lydia and Conor, how do you see that moving forward? What are your views on that? Lydia, perhaps I'll come to you first, yeah?
Perfect, yeah. So I suppose firstly, thanks very much, Maeve, for sharing your story. And I think your experience really highlights the difficulties that can arise where a family falls outside of the Children and Family Relationships Act 2015. And in the research that I have just completed, unfortunately, many families are in a similar position where they fall outside of the legislative procedure. In terms of the known donor question, I suppose I'm not 100% sure on what the official reason is, but my feeling is that it was a concern for the rights of that donor, to make sure that his rights were protected in the process. And, you know, that is, I suppose, a delicate situation in terms of creating a legislative response to it. But I think it can be done. And in particular, it could be done through a court process that allows for a declaration of parentage to be issued in a case of a non-clinical procedure or a clinical one where a known donor has been used, with safeguards built in to the process. So, for example, the known donor could be required to give consent in order for the declaration of parentage to be issued. And then also using the court process can allow for other safeguards to be built in, for example, around protections for the child's right to identity and ensuring that the best interests of the child are upheld at all times. And that could be done via an amendment to the Children and Family Relationships Act, using, as Maeve suggested, the new AHR bill as a way to facilitate that amendment. So there's certainly ways to address it. And I think that it really needs to be addressed, because it means that currently we have children conceived in really similar situations, one in a clinic and one not in a clinic, being treated differently by the law. And you know, that's something that we certainly need to address in terms of an amendment to our existing laws, in my view.
Thanks, Lydia. And I think, Conor, you had spoken about this in your report, didn't you?
Yeah, I mean, and I won't, I'll save the time for other questions, because I agree with everything Lydia just said, so I won't waste any more time on this issue.
Thanks. Well, I suppose another issue that's often raised, and it's been raised today on the panel, is in relation to surrogacy. So one of the things is on surrogacy abroad. Many families have already been formed through surrogacy, which has been accessed abroad, and the majority of people who contact are planning surrogacy are planning to do so abroad. But the proposed legislation on AHR doesn't cover international surrogacy, as you were talking about, Conor, there. In your view, Lydia, you know, how, and Conor, how should international surrogacy be legislated for to ensure it protects all of the parties?
Yeah, well, I'd probably defer now to Conor, because he's put together very comprehensive provisions in terms of his report on what international surrogacy might look like. So I'm happy to pass over to Conor on that.
And perhaps I can throw this in the context of, we have a question in from somebody who says that, hi, myself and my husband going through a surrogacy journey through Canada. We'll have a Canadian birth cert for the child, which will both be listed on, but only one of us will be the genetic parent. Will we have legal protection using the Canadian birth cert? And I think that in Ontario, they've changed the law recently. It depends on the provinces, but you'd be added in, you know, on the birth cert before you leave Canada. So, Conor, what?
Yeah, I mean, I suppose on the birth cert point, and this is similar to some of what Maeve was describing earlier on, the fact that you have a birth cert from another jurisdiction doesn't determine what happens in this jurisdiction. So it wouldn't, you know, it wouldn't be the key thing as long as our law remains unreformed. That wouldn't really make a decisive difference here, unfortunately. I mean, with respect to international surrogacy, you know, what we have at the moment is just unsustainable in my view. This idea that we have and I'm not sure what the best word for it is, but it's a real kind of twilight zone and trying to bring people in a situation where we don't have dedicated laws on the issue, where we have sort of administrative circulars from government departments, which have no particular legal status, which are steering people in different directions. You know, we do need to have a specific fit for purpose tailored framework for dealing with these cases. And I suppose in the report, what it recommends is a series of criteria which would provide that pathway through which people could apply to court to have a surrogacy arrangement in another jurisdiction recognised here and parentage awarded on that basis, while at the same time providing the additional kind of robust safeguards which are needed to recognise the fact that international arrangements do carry a little bit of additional risk compared to the domestic ones. So when things cross borders and when different legal systems interact, there is a bit more risk involved with that. So it's about trying to recognise that and mitigate that, ensure that the laws of the jurisdiction where the arrangement took place are, first of all, both complied with, but secondly, also compatible with our vision of what would be a children's rights compliant surrogacy framework, and that all the parties' interests are protected and that everybody has fully consented and so on and so forth. So as I said, the precise detail is in the report, but I mean, I do think it's very possible to do this. Whether the political will is there to do it is another question. There's been media reports suggesting it's not going to be done. This is not beyond our collective wish as a government to provide legislation which can get this right. So I really think if we don't do it now, when are we going to do it? It would be a real missed opportunity.
Thanks. And another question we have on that, and I know in the report you talk, and you've referenced it there, of incentivizing people to remain in Ireland and have their procedures in Ireland, and that way to have it go to the High Court for when you're dealing with an international, rather than in advance of going to the district court for domestic surrogacy. And one of the questions coming in is for you, Professor Manny, do you anticipate there be enough women to act as altruistic surrogates in Ireland to meet that demand of same-sex or opposite-sex intended parents?
Yeah, I mean, this is a tricky issue, and you know, it's impossible to say that for sure in advance, but I mean, I think it would be reasonable to speculate that may be a difficulty. That we're a small country, where there'll be a small pool of people potentially willing to put themselves forward for this. And so it would be reasonable to say that there's a tension in the report between, on the one hand, that I'm saying we should incentivize domestic, while on the other hand recommending that the domestic framework be for altruistic surrogacy only, and that would be a reasonable critique of that. The thinking behind that really was that the brief that I had, the terms of reference that I had, was very much around looking to our international children's rights obligations and the output of the bodies charged with that. The UN Special Rapporteur on the sale and sexual exploitation of children had issued a number of recent documents expressing an awful lot of concerns around commercial surrogacy. And so in essence, I was finding it extremely difficult to square recommendations that commercial surrogacy be legislated for in Ireland with some of that guidance. Whereas commercial surrogacy abroad, we can't prevent commercial surrogacy in other jurisdictions, and we still need to have a pathway for recognition of those. But when it comes to domestic, ultimately, I just found I couldn't quite square that circle. And so, yes, it could create a situation where shortage of altruistic surrogates would lead to continued reliance on international surrogacy by Irish couples. That's entirely possible.
Okay, thanks, Conor. And Maeve, I haven't come to you at all. I mean, in relation to these two issues, in relation to what you've heard there, you're hopeful, obviously, that the matter will be resolved, because you end up in this bizarre situation, as you say, this kind of corollary for your two children. What's your feeling on the proposals if they happen? Will they be enough?
Yeah, I'm sorry, I will have to drop off after this. But thank you for bringing me back in. And I am really hopeful, and I do completely agree with Dr. Mahoney that this is like a twilight zone, and children are in legal limbo at the moment, and it's not acceptable, and that this is the time to act and to do something about it. I also, Dr. Bracken made a really good point that I hadn't said in my kind of spiel about the opportunity to make agreements with a donor or a surrogate. It's all possible to come to legal documents and agreements that are everyone's been informed about, and everyone has had legal advice on, and maybe even help from a psychologist to the implications of this, so that everyone's very clear on what will happen and what their roles are. And for us, as I said, we couldn't go through a clinic, so we took the forms that were there, and we signed those forms as if we were in a clinic, and that was the best solution we could come up with. But I do think all of this is possible and should be legislated for, and I really hope it is. It would make such a difference.
Thanks, Maeve, and thanks very much for your contribution. Just if you have to drop off there. The third issue that I want to come to Lydia and Conor about is that of adoption. Many people coming to this the first time go, isn't adoption grand? Sure, can't you use that to overcome any difficulties you have about parental recognition? So Lydia, can I come to you? Why isn't that working, or why should that work?
I think, adoption is obviously a multifaceted area, and for some parents, they might wish to engage in a second parent adoption, but a difficulty in relying on it as a solution is that it's not designed to be used in cases of DAH or in surrogacy. It's not really a solution. It doesn't reflect the reality of the relationships that are created through either of those processes. So it would be far better to have a comprehensive provision to regulate DAH or in surrogacy, rather than using adoption as kind of a fallback. And I think the way that you're suggesting some people might view it as. There's also, I suppose, a practical issue in that for second parent adoption under our current law, there is a 2-year waiting period. So similar to the rules on guardianship, you have to care for the child for 2 years as a step parent before you're eligible for that form of adoption. And then also a practical issue is that it has been reported that the Adoption Authority doesn't actually facilitate second parent adoption in cases of DAH or in surrogacy. So it's not actually an available mechanism at the current time, at least. So there's, I suppose, a whole host of different reasons why it's really not appropriate to think that is the answer, when in fact we should be looking at how can we create comprehensive DAH or and surrogacy legislation.
Thanks, Lydia. And Conor, do you have anything to add on that?
I mean, just briefly, that waiting period is one important issue. Obviously, I mean, we're trying to get away here from having this hiatus during which people can't access legal rights or responsibilities in respect of their children. So that's one issue. But I mean, as Lydia mentioned there does appear to be a bit of a disconnect between the letter of the law, which on paper looks like it might facilitate these kinds of situations, and the actual practice of it. And when Lydia mentioned there the fact that in some cases people attempting to use adoption in relation to surrogacy, for example, isn't working out. One issue I've heard reported on that, and on a number of occasions, relates to people who have health issues. For example, the reason that they went down the surrogacy route in the first place might be that they are a cancer survivor, for example, and then that health status becomes a factor which is looked at in the course of an adoption application, which might then be a barrier to being approved for adoption later on. So that's just one kind of practical example of how adoption can differ in practice from the theory, whereby you might look at the relevant act and think, oh, this is available, and in practice it's not really working. So no, I mean, we need bespoke laws here. We can't be relying on square pegs and round holes. We need to actually deal with this on its own terms and put in place properly dedicated laws.
Great. Thanks very much for that. And I think that in the meantime, while we're waiting for those, hopefully those laws are going to come. But I think, Lydia, in your report, two of the elements of your recommendations are, pending that, we need better education. We need people to assist them. I mean, it's a minefield. Here we are, lawyers kind of scratching our heads and looking at this. If it's difficult for us, you know, so many intending parents are excluded, and ergo so many children are excluded from their rights. So, I mean, we can embark on those things now, can't we, Conor and Lydia, at the moment, the education, the training, the resources, and in the meantime.
Yeah, absolutely. I think accessible legal information is really important. You know, that really strongly came through again in the research. People not really understanding the laws fully, but then also when they were engaging with court processes, finding it incredibly stressful and intimidating. So having some accessible way to approach those court processes would be very important. And also accessible legal information. I've been researching this area for nearly 10 years, and I still get very confused when I'm looking at all the different laws. So, you know, for someone coming to it for the first time, it can certainly be very daunting trying to figure out what the legislation actually means or what it says. So having access to that sort of information would be very important as well going forward.
Yeah, and just one thing to add quickly to that. I mean, the point was made by Maeve earlier on, guardianship is not parentage, and that's very true. But in the interim, I mean, we don't know how much longer we're going to have to wait, hopefully not that much longer, but it's been a very slow process, and we could be waiting another while yet if things don't go well for these laws to find their way into effect. So in the meantime, you know, when people do become eligible to apply for guardianship, my suggestion would be that people really should, because it might not be everything you want, but it can certainly fill the gap. It can bridge that gap in important ways in the meantime. So people should be aware of that and should make the most of what they can use, hoping that we are ultimately going to reach a better place down the line.
Well, thank you very much on that note, on that positive note, Conor. Hoping that we will be in a better space when we come back, and no doubt if we are, it'll be very much thanks to both of you for your immense work in this area, and hopefully when we get to meet Maeve's new baby, there might be something different there in relation to her status and that family, so, and all the other families around Ireland. And I just want to say thank you again to Professor O'Mahony, and thank you very much to Dr. Bracken for all your research and in relation to this report, and thank you for coming today. I want to thank all of the attendees for coming along. Please tell all your friends, tell all your enemies, tell everybody that the video will be up there online, and everybody can see it. We will get back to the people who've left some questions we couldn't get to today. We'll be back to those individually, and please contact LGBT Ireland at any stage with any of those queries. We're there to help, and I just want to thank Paula and the whole team at LGBT Ireland as well, and thank you Maeve Delargy, Dr. Bracken, and Professor O'Mahony, and hand back to Paula.
Thanks, Roddy, and thanks so much everyone again. I'll let people go because we said we'd finish on time, but Roderick, thanks so much for all your great sharing up today, and I certainly learned a lot. There's so much to know in this area, so thanks everyone, and do check out our website lgbt.ie, and we'll have the recording up there. So thanks everyone.
Thank you. Bye-bye.